we also have to understand that the need for informalism, as we saw, came from the kind of crisis in the legal system. And importantly, the crisis was not so to be addressed by, um, like I said, expanding legal aid or by increasing the number of judges so that there'd be less pendency. Rather, there was almost a kind of a giving up of any attempt to successfully work the civil or the criminal justice system in India. And perhaps nothing illustrates the kind of extreme crisis the Indian legal system has faced in this era than the Bhopal gas disaster. And now, remember, Bhopal gas disaster is almost 35 years, 36 years back now. So it's literally equidistant in terms of time between the Constitution and now. So for 35 years of the Constitution, that disaster happened, and 35 years has passed since then. And I think still the pathologies of the Indian legal system are best illustrated through what happened in Bhopal, and also to understand the thought behind PIL, the idea behind PIL. Now, what does the, I mean, I will not go over too much of the fact, but just the legal aspect which compares to PIL. You know, the thousands of poor Bhopalis were killed, and many were medically, maimed for life. What was interesting was that soon after the litigation, soon after the incident, the Indian government passed a legislation where they took over the rights of the victims to litigate the issue, right? So let's say, let's say something like this happens, that everybody in a college, whichever college you work or studied in, everybody in the college dies because of a horrible incident, right? Every student, every professor, etc., right? Some 1,500, 2,000 people, let's assume that the side of the college dies or at least is physically injured in a severe manner. So instead of all the people in the college being able to sue the entity which has caused the incident, the government takes it up and says that you can no longer litigate this issue because you're incompetent. Basically, you will not be able to successfully. You're too small an entity compared to a large corporation like Union Carbide, and so it takes it up. And interestingly, it first files a suit against the company in the United States, right? And what happens in the United States is very interesting, because what the company claims is something called forum non-convenience. It's a doctrine that it's an inconvenient forum for the defendant, that is the company. And Indian government, on the other hand, claims that actually it's a more convenient forum. And very interesting arguments are made. The Indian government is saying that basically US is the more efficacious place for litigating this issue. That Indian legal system is actually not ready to litigate something as complicated as this. The Indian tort system is not really fit for this. So what happens is the Indian government files an affidavit from an American law professor who has studied Indian law, Mr. Mark Galanter, who I recommend as one of the most interesting scholars writing on Indian law. And everybody should read him if you haven't already. Especially his work on caste is well known, but even otherwise. So interestingly, Mark Galanter files an affidavit saying Indian legal system is not fit for this. And this is for the Indian government he files. And who does Union Carbide to get file an affidavit? Nani Partiwala. So Union Carbide gets one of India's most famous lawyers to file an affidavit saying India is a great place for litigation of this kind, and they should just go back. So eventually, the US judge, of course, decides that it should be sent back to India. What happens once it comes back to India? The Indian government files a suit in the Madhya Pradesh District Court. And of course, anticipating that the suit will take some time to adjudicate, the government asks for interim relief. After all, the suit can go on forever, right? So, and Madhya Pradesh court, the Bhopal District Court gives some interim relief of, I think it's 150 crores, if I'm not wrong. Union Carbide files an appeal in Madhya Pradesh High Court, and finally in Supreme Court against this interim relief. Now, what's happening is that when this interim relief is being argued in the court, while that interim relief is being litigated, the Indian government enters into a settlement with Union Carbide for a certain amount, $470 million, which is actually a very small proportion of what was anticipated would be what was initially sued for, and that settlement was deemed to be binding on, of course, all its victims, all the Bhopal victims, for both civil and criminal remedy, right? So this was, of course, greeted with complete shock, because obviously the people who were affected by the tragedy were not even consulted. It was just the government and the company, allegedly hand in glove, and that becomes the basis of the settlement. And the people were, in a sense, not even made a part of this entire process. So some people file a review petition against this. And what is interesting is the arguments that are made by the court to justify, because the court feels attacked as well for this perfidy of basically enabling the settlement between the government and the company. And the court makes very strange and interesting argument that basically these people are incompetent. They are, they are not fit to be able to litigate this issue. And it says that the suffering of the people of Bhopal was such that they wanted to enter into an interim settlement. I mean, obviously, this is a dishonest argument, because interim relief had already been ordered, and that interim relief would have taken care of the immediate, to some extent, taken care of the immediate suffering, and could have, instead of settling the issue for good, it could have been a much larger amount could have been arguably garnered through the proceedings. But so what is interesting for our purposes for the study of PIL, it is a judgment. This is a process in the late 80s, at the heyday of PIL, the rise of PIL, the great period supposedly of the Indian Supreme Court. And what the court says basically is that it deploys the arguments it has honed to perfection, thanks to its working of PIL, that is the suffering, that people are suffering, and therefore we have to do whatever we need to do. And even if we have to enter into informal settlement, and also that people are incompetent to litigate themselves, right? That also becomes the basis of PIL, as you know, that because people cannot litigate themselves, somebody will litigate on their behalf. That idea. So that is what is going on in this period. That idea of informalism as panacea is getting further and further entrenched in this entire period. The result of this, this process continuing apace in the 90s, is what Justice Hidayatullah, one of the retired Chief Justice of the Supreme Court, he gave a lecture in 1984 in the early period of PIL, where he said that the way PIL is proceeding, it may lead to an annihilation of procedure. And actually, that is what has happened, is my argument, right? That from the 90s, this logic of relaxing evidentiary standards and of removing the petitioner, as we saw in Sila Barse, is taken to its reductio ad absurdum. So from the mid-90s especially, there's a trend starting from the Jain Hawala case, a case called Vineet Narayan, where the court appoints an amicus curiae. What they did in this case, it removed all the other, the court removed all the other, basically said that the amicus curiae will be responsible for the case. It did not allow all the other parties to, in a sense, approach the court directly. And it, this idea that amicus will handle the case and the state will, of course, be directly concerned. So this idea of a continuing mandamus, as they would call it, started from then onwards, where a court would supervise a relief or a process through amicus, through appointing its chosen amicus. Now, this was in the mid-90s, but since then, this has become fairly routine, and the court has done this repeatedly over the last many years. The most well-known of this is the so-called forest case, a case called T.N. Godavarman Thirumalpad versus State of Tamil Nadu, which was about one particular forest in the Nilgiri Hills of Tamil Nadu, became a case about all of Indian forests. So for more than 2 decades now, this case has been going on, and the court has set up what's called a forest bench, which sits every Friday, and basically it's become like a supervisory entity, um, you know, looking at all the forest policy, all the forest, basically any diversion of forest land for non-forest purposes has to go through the court. Um, but and it had appointed Mr. Harish Salve as the amicus, and he was the amicus for almost 2 decades. Um, but this process led to obvious problems. Mr. Harish Salve, of course, has been the amicus in most of these very important cases, um, which made him rather influential in litigating them. So the example of the abuse that can arise from this is, I would take the well-known Niyamgiri Hills case. This is a case of bauxite mines in Odisha in Kandhamal. Sorry, not in Kandhamal. This is the Dongria Kod community, I think, in Odisha. The question was about whether forest land where this community lives can be diverted for use by Vedanta, which is this company which had built an aluminum factory to be on site, right? From these factories are normally built as close to the mines as possible. Now, what was interesting was in this case, the tribal community also tried to intercede to give their point of view in the case. And Mr. Sanjay Parikh, well-known advocate, was hired by them to speak on their behalf. But the court said they do not feel the need to hear the tribal representatives. I mean, the point of view of the community. And instead, they basically went ahead and heard all the private parties, that is Vedanta and the various, the company which was interested, then the government, which was apparently hand in glove with the company, and Odisha Mining Corporation, which of course is a governmental arm, and the amicus. The amicus himself had actually, Mr. Salve himself, in fact, had recused from the case because he was in a retainership with Vedanta. And very importantly, it became very controversial because there was an allegation that one of the judges, Mr. Justice Kapadia, had owned shares of Sterlite Industries, which was arm of Vedanta, and therefore there could be allegation of conflict of interest. Now, this can happen, right? I mean, it's not wrong to own shares of a company or the other. But the question is, if there's allegation of conflict of interest, there has to be somebody who can bring up this issue, right? And the judge can decide whether he wants to recuse or not. But in this case, because all the parties were on one side of the case, there was nobody to even ask for recusal. So this is the kind of problem this kind of thing leads to. And this idea that Justice Pasayat at the time in the bench basically argued that they don't have to hear the tribal community because the court can take care of the interests of the tribals. And this kind of noblesse oblige kind of idea of like, they will take care of the interests is actually is what the kind of problem that PI leads to. And this is not just a one-off instance. There are many, many, many instances of this kind, as we will see. But perhaps the most extreme version of what PI can lead to is the rise of so-called suo motu cases, right? So this is a case called in renetworking of rivers, about the so-called interlinking of all the rivers of the country. So in 2002, 15th August, the then president, Mr. APJ Abdul Kalam, made a statement, the presidential address to the nation on Eve of Independence Day, where he suggested that, there was drought in parts of the country and there was floods in other parts of the country. Instead, so why don't we just link all the rivers with the country? Now, this address was brought to the attention of the court when another case was being heard, which was also suo motu, which was called In Re Quiet Close the Meli Yamuna. So this was the case which the court had been hearing since 1994 about cleaning up the Yamuna. And in that, the amicus in that case, Mr. Ranjit Kumar, brought to the attention of the court that, this is a suggestion from the president. Remember that is about river pollution, right? Not about drought or anything, that particular case. The court decides, this is a good point that Mr. Kalam has made, and proceeds to issue notice to all the states and the center with regard to this proposal of networking of rivers. This is under the Chief Justice, Kirpal, B.N. Kirpal, who was the Chief Justice at the time. And this is August, I think around August of 2002. Of course, as usual, the states do not file reply in time. And Mr. Kirpal was about to retire, I think, end of December, early January 2003. What he does is that since notice had been issued and almost no states had filed a reply, and the center was keen on it. And so was state of Tamil Nadu, which is a water deficit state and very keen on, Kaveri waters from Karnataka, etc., etc. You're familiar with that. And the court then said that, well, since the states have not replied in time, we take it that they are in agreement with this proposal. And they went ahead and decided to order the government to consider the feasibility, etc. So over the next few years, they heard this case, and they basically ordered the center to consider the implementation of this mammoth project, probably the largest engineering project in Indian history, more than $100 billion. The first result of it is imminent in Madhya Pradesh, in two rivers there being connected. I think it's Panna River and I forget the name of the other river. Arguably disastrous consequences environmentally, but even in terms of the cost is quite remarkable. But that's the nature of what PIL had led to, that the court did not need to consider all of these aspects. And let's say, the ambitious ideas could be taken up without any hesitation by the court. That's the nature of the annihilation of procedure that PIL